As a building code administrator, I have had the opportunity to work with some fantastic code enforcement staff. This training on the legal side of the legalism and management of your exam and your training is very valuable for you, and I hope it's very helpful for you. So let's get started. We ask that you like and subscribe these videos.
The professional staff at the Building Code Administration Office must understand the principles of constitutional law as they affect the daily administration and enforcement of building codes before resorting to forceful measures. Always seek the advice of the municipal attorney before forceful or legal action is taken. Whenever the building code requires notice to a party, notice must be given by the building official before a charge can be brought. It is a condition precedent, and any charge filed without the proper notice is subject to a motion to dismiss. It also serves common sense. How can the citizen correct a violation that they do not know about or understand the needs for correcting? The notice must contain each element required by the code provision, usually the name of the responsible party, the location of the property, the nature of the violation, and a deadline for correction and notice of the defendant's right to appeal. The notice must be served in a manner that complies with the code, whether it is certified mail, personal service, or posting. Notice of violation is covered in the IBC and provides that the building official is authorized to serve a notice of violation or order on the person responsible for the erection, construction, alteration, extension, repair, moving, removal, demolition, or occupancy of a building or structure that is in violation of the provisions of the IBC or in violation of a permit or certificate issued under the code. The order must direct the discontinuance of the illegal act or condition and the abatement of the violation. The I-codes also provide building officials the authority to halt construction activity immediately if deemed necessary. Building officials have the authority to stop work until code violations or other hazards to the public safety have been resolved. If, during the inspection process, it is found that the work is not going according to the plan submitted, the building official may wish to take summary action to revoke the permit or to issue a stop work order. Issuing the stop work order is the recommended first procedure. A stop work order is immediate action taken to abate a violation without formal court proceedings. Stop work orders are authorized by the IBC. A stop work order shall be in writing. It shall be provided to the owner or the owner's agent. It shall cite the work that must immediately cease. The order shall state the reasons and the conditions under which the cited work will be permitted to resume. The order must provide further direction for due process. Before issuing the stop work order, it would be suggested that the building official and contractor or owner meet first. And remember, all communication may become part of a legal record in future proceedings. After other administrative relief options are exhausted, an injunction may be sought by the building official. The remedy is, in essence, an order of the court which requires that the defendant cease and desist from all conduct that amounts to a violation of the building code. In almost every jurisdiction in the United States today, injunctive relief is broken into three types: a temporary restraining order, a temporary or preliminary injunction, and a permanent injunction. A temporary restraining order is an order issued by the court without notice to the other party and without an opportunity for the party to be heard. A temporary injunction is a judicial order that is issued pending a full hearing by the court. And a permanent injunction is a judicial order that is issued after the court has heard all the evidence in the case. The factual circumstances and legal standards that must be met in order to receive a temporary restraining order or a temporary injunction should generally be known by the building official so that an educated decision can be made whether to seek either. Both the temporary restraining order and the temporary injunction are usually subject to four legal requirements. First, the building official seeking the injunction must show that there is a significant threat of irreparable harm to the public if the injunction is not granted. Second, the building official must show that the harm the public would suffer if the injunction is not granted is greater than the harm that the other party would suffer if the injunction is granted. Third, the building official must show probable cause that he or she will prevail on the legal merits of the controversy. And fourth, the building official must demonstrate that the issuance of the restraining order or injunction is in the public interest. A significant portion of time is spent by building code departments responding to complaints regarding parcels of property. Some general guidelines relating to handling those complaints may be useful. First of all, the person who receives the complaint should obtain as much information as possible: the name of the complainant, his or her address, phone number, the date that he or she viewed the alleged violation, and the nature of the alleged violation are all important. It is also important for the person who handles the complaint to realize that the job of the Codes Department is made easier when the citizenry of the jurisdiction cooperates. Once a violation has been found, some action must be taken to enforce the code. Ordinarily, if the structure has been completed, the summary procedures of the revocation of a permit or issue of a stop work order are not available. Once the construction has been completed, prosecution in the city courts becomes the final method of enforcement. In most jurisdictions, a civil or quasi-criminal complaint may be filed against the owner or occupant of the property. Normally, with a civil complaint, the notice of violation may be served either through the mail or physically delivered to the alleged offender. In some jurisdictions, an alleged offender is still required to be arrested under an arrest warrant. A typical complaint in most jurisdictions will contain 6 elements. The first being the name of the person or entity. The first decision that must be made when a complaint is prepared is who is the party to be charged. Answering this question correctly will prevent lawsuits for false arrest. Designating the charge. Every complaint must contain the section number and the name of the violation. Body of the charge. Every ticket must contain a description of the violation which is sufficient so that the defendant can defend against the charge and to make sure he or she is not charged twice for the same offense. Date and time of offense. Each complaint must contain an allegation regarding the date and time of the offense. For ordinance violations, the date must fall within the statute of limitations. Signature of the complaining witness. Each complaint must be signed by an individual, either an inspector or a witness. Finally, number 6, notary or affidavit. Depending on the jurisdiction, a complaint may need to be verified by the person signing it, that is, sworn to under oath that the information contained therein is true and correct.
Remember to subscribe, like, and support these efforts that we're having for you, and we wish you the very best of luck in your professional development.